few of you, and very few people in general, pay attention to who their judges are or what those people are up to. Do all of you live in Butler County? No. Most of you do. Where else? Where are counties? Hamilton County? Warren County? I mean, how many of you could actually name, so most of you are the 12th, how many of you even know what appellate district you're in Ohio? If I say you're the 12th appellate district, how many of you knew that beforehand? A few of you do. Most of you say, well, 12th district, what the heck is that, right? I mean, there's only so much time in the day. You can only learn so much of this stuff. How many of you know how many judges are in the 12th district? How many of you know what the 12th district is? 12th district is the collar counties around Hamilton County. That's an appellate district. So if you have a trial case here in Warren, Butler, Claremont, and you want to appeal that, it goes to the 12th district, then goes to the Ohio Supreme Court. How many can name one judge from the 12th district? Appellate judge. All the guys in the back, they're probably sandbagging. They're probably from there, right? So, okay, don't badmouth the 12. Gotcha. Well, there's 5 of them, and these are people that have a tremendous amount of say over your rights. And in fact, I would submit to you that the most important branch of government, which at the same time liberty groups like yours and people in general are most neglectful of, is the judicial branch. The separation of powers both at the federal level and at the state level envisions that legislators will be captured by special interests so that they can get reelected, or so they can dole out favors of one kind or another, or simply because the public spirit, the heartstrings it's for the children kind of legislation gets the better of them, right? But the separation of powers envisions that these kinds of acts will be struck by judges, that judges are to be the guardian of our constitutional rights, or otherwise it's just the legislatures who guard our constitutional rights. So there are a few quotes that I really like from Madison on this issue, because we've really, in this kind of discussion, the word judicial activism has been bandied about so frequently that we're not really sure judges should be striking down laws anymore sometimes. But I think that this is helpful. So when Madison devised the federal Constitution, a few of the things he said were this: courts are bulwarks of a limited constitution against legislative encroachments and must guard against dangerous innovations in the government. And courts must declare all acts contrary to the manifest tenor of the Constitution void. And I find that quote very interesting. Must declare all acts contrary to the manifest tenor void. Because if you go back to Section 1, Article 1 of the Ohio Constitution, which talks about natural rights and the purpose of a constitution being secure liberty and freedom, you say, well, that's the manifest tenor of the Ohio Constitution. So they've got to take that into consideration when they're looking at one of these regulations of your life, regulations of your property, regulations of your business, excessive taxation of your home or income or whatever it may be. So that's something that's very interesting to me. And Madison continued, without courts doing this, all the reservations of particular rights or privileges amount to nothing. And isn't that really true? If the legislature passes a law that violates this plain text of the Ohio Constitution that we just went through, but the judges simply rubber stamp it and say we're going to defer to the legislature, well, you've simply lost that right. That right doesn't exist anymore. It might be there on paper, but it's as though it's not really there at all. So these people have a tremendous amount of ability to protect your rights. And if this Constitution, if the things that are in here are enforced, most of your problems in state and local government go away. It really is that simple. If most of the things on here were enforced in reality as they are written in this Constitution, most of the things you have problems with aren't problems anymore. So it would certainly seem to make sense to pay attention to these judicial races and to also consider whether there are things that we can do to reform this process to get judges to better safeguard our rights. The problem we have today is that Ohio judges are very deferential to the legislature. In fact, I would go so far as to say that most Ohio judges are essentially glorified secretaries for the legislature. And that's not to offend any secretaries in the room. If you are a secretary, you actually perform very important functions that you voluntarily agree to perform for your boss, and he asks you to and wants you to perform those things, and they are beneficial to society. But the problem is that judges have become kind of handmaidens, and they view their job as to rubber stamp legislative acts as constitutional, even if they're not. And what we've forgotten is that the deference should not be to the legislature, but the deference has to be to the Constitution. The judge's job is to follow the law, and the ultimate law is not that passed by the legislature, it's that in the Constitution. That's why you take an oath to the Constitution. You don't take an oath to whatever legislative act comes across the table. And Ohio has moved more in this direction. At one time, Ohio Supreme Court decisions had to be unanimous in order for an act to be struck down. And the funny thing is, more acts were struck down back then when a unanimous decision was required than are struck down today, when we only need 4 out of every 7, or 4 out of the 7 Ohio Supreme Court justices to strike down that act. And why is that happening? Well, what we've had probably since the 1960s or 70s is sort of a conservative adoption of progressive policies for judges. So a lot of you are kind of just learning about progressivism in the past few years. But what you probably haven't learned about is what progressive judging is. Well, Woodrow Wilson laid out this plan whereby judges were really to just rubber stamp legislative enactments. The majority rule was to be elevated above individual rights, above constitutional rights. And he said, his most famous quote, or one of his most famous quotes, Wilson this is, "The old constitutional order was standing in the way of progress." Well, that says it all, right? And his argument was that the Constitution was not to be interpreted as a fixed limit on government authority. He said that that was a Newtonian view of the Constitution. Newton, his fixed rules of science, right? Instead, he favored a Darwinian view, a notion that the Constitution could live and breathe and evolve. Of course, not recognizing that constitutions already have a means of living and breathing and evolving through the amendment processes in the Constitution, not through judicial reinterpretation of those same words. Wilson indicated that we were all like a big family, and that everything that we have should be at the disposal of the Father Sovereign, was his term. So this was his view for America, and to implement this view, he appointed judges to the federal bench who he knew would defer to the administrative state. So they developed this notion that administrators were experts, and we should defer to them in all cases where we can. And that the general welfare, which had previously meant all people, the welfare of all people, could just mean the welfare of one person or another. And the notion was legislative deference. The notion was who were judges to question whether the Congress or the state legislature really was doing the right thing or not. These are questions of whether the act was wise, not whether the act was constitutional. And this changed everything. And we can see this today. And so, this progressive judging was mostly just on the left. But after Roe versus Wade in the 1970s, conservatives began to say, wait a minute, we don't like this idea of judges inventing rights out of thin air. And so anytime a judge finds a right, we find it objectionable. And this new judicial philosophy of judicial restraint began to take hold in the conservative movement, in the Republican Party. But this notion of restraint, which of course, restraint is usually a good thing, subject to Barry Goldwater's famous quote, right? Extremism in defense of liberty is no vice. But this restraint notion quickly morphed into a notion that you should never strike down the law of the legislature and that you were being activist when you were striking down a law passed by the people through majority rule. Well, what we've forgotten is that mob rule isn't how we run a republic, right? This is not a democracy, it's a republic. That means there are certain rights that we have that are off limits from democracy. There are certain rights that you have to run your own life that aren't subject to a vote. You know, we don't open up the vote on whether to have slavery back, right? And say, well, if we get a 51% vote, we're going to go back to slavery. And the same, of course, is true for your property rights, your economic liberties, and all kinds of other freedoms. So what we've gotten to is a point where the real activism we should be concerned about today is ignoring the Constitution simply to rubber stamp the legislature to make good with them and sweeping away the people's rights and the plain words of the Constitution in the process. So let's look very quickly at how Ohio judges are doing this and why you should be concerned. Most of the Ohio judiciary employs this presumption of constitutionality, which is really fabricated out of thin air. There is a rule of construction passed by the legislature telling the judges, when we pass a law, we want you to pretend that it's constitutional as much as you possibly can. And only if you can absolutely find that it's not should you invalidate it. So the judges have gotten to the point where they use this presumption of constitutionality when you challenge government spending, or government imposition upon your rights. And they say that you've got to prove your case as a citizen beyond a reasonable doubt before you can win a case challenging government action. So every conceivable presumption is in the favor of the government. What's interesting is where this presumption comes from. Does anybody know? This is the presumption that all laws are presumed to be constitutional when they're passed by the legislature. Does anybody know the underpinning, the philosophical underpinning of this law? The philosophical underpinning to this law is the notion that the legislature, in passing its enactment, has carefully considered the constitutionality of the measure before passing it. So it would be rude to step on their toes because they've already thought about it. Remember, nobody said, "What? Are you serious?" back then when they were asked constitutional questions, presumably. Right. So this was the great jurist Thomas Cooley was the scholar in the 1800s who developed this presumption of constitutionality notion. And what he said is the legislature is presumed to have carefully considered the constitutionality because they take an oath to the Constitution when they go into office, right? So they obviously have considered it. If they voted yes on this thing and passed this law, there's a pretty darn good chance it must be constitutional. So we should defer to the legislature. How many of you believe that legislators carefully consider the constitutionality of enactments before they pass them? Show of hands. Anybody? Well, this is the purpose. So the reason for the presumption of constitutionality no longer exists. Yet courts are still employing it. Instead, what we have is legislators, city councilmen saying, let's just pass it and let the courts figure it out. And we have the courts over here saying, well, these guys figured it out, so we shouldn't figure it out. And so this imaginary game of ping pong with our constitutional rights, where nobody's actually doing the hard thinking on whether an enactment is actually constitutional or not. We have serious problems as we go on with standing in the Ohio courts. How many of you have read about some of the recent standing cases? Anybody? Well, there have been some interesting things going on, and this has been going on for longer than these few cases, but in the past few weeks, this issue has bubbled up a little bit. There's a left-wing group, Progress Ohio, that has challenged Governor Kasich's Jobs Ohio bill, and then also the Ohio Business Round, actually just the Ohio Roundtable, challenged some casino gaming actions as unconstitutional. And in both cases, they were thrown out of court as unconstitutional. Well, what they sought to do was use this Article 8 that we just talked about, this corporate welfare limitation, saying government can't pick winners and losers. Government can't take my tax money and give it to a private corporation just because maybe he made a donation to the governor or whatever. So even though these are left-wing groups bringing these challenges, these are things that most of us can sympathize with in terms of their substance. There may be some procedural issues with those cases that I would quibble with, and we can talk about those later. But in both cases, the Ohio Courts of Appeals threw their claims out and said taxpayers don't have standing in Ohio. And this is really quite a remarkable ruling, because taxpayers have always had standing in Ohio, ever since the 1851 Constitution. There's no prohibition on you having standing. And just so I'm clear, standing means that you have the right to sue to stop the government from doing something illegal. So they're making an illegal expenditure on corporate welfare. The legislature is violating the single subject rule, for example. So they pass this bill. You want to challenge this bill in court and say this is unconstitutional, it should stop. The uniformity clause. Any of these structural restraints on government. The notion is that you should be able to walk in court and say this is my tax money going to these people, this is unconstitutional and has to stop. And for years it was that way. And judges have begun to fabricate this standing rule, which is at the federal level, but has no place in Ohio courts. The reason it's at the federal level is because Article 3 of the United States Constitution says you need a case or controversy to be in court. And so what all these Ohio judges do is cite to the federal Constitution. If you read the Progress Ohio case, you might not like them, I don't like them, but it's a little bit concerning because they just rely on the federal Constitution for the presumption that all Ohioans need standing under the state Constitution. And so Section 16, of course, the Ohio Constitution allows access to courts for just this reason. So again, it's kind of an activist judging, fabricating barricades to keep you from protecting your constitutional rights. And again, all this stuff is nonpartisan. These are Democrat judges and Republican judges alike. There's virtually no difference on some of these important issues. The police power. Does anybody know what the police power is? It has very little to do with the police. The Ohio judges call it the power to protect the public health, safety, welfare, and morals of the time. They say that it can change based on the necessity of the situation. Case by case, it can change. It shrinks and it expands, and it depends upon the needs of the day, as defined, of course, by them. So we have this police power, and the notion is that you can regulate away many of your property rights by use of the police power. That's an inchoate right that the legislature has that is kind of everywhere and all around us and can subsume the rights enshrined in the Constitution. And it's constantly growing larger and larger as we see everything done under the moniker of public health. I hope some of you have taken notice of that. It seems like the two most dangerous words in the English language today are public health, right? Because you can be forced to do anything in the name of public health. Almost everything fits in these public health regulations. And courts simply roll over when the government says public health and say, well, sorry about your property, but this is a public health issue. You know? And it seems like a day might come where we're all doing jumping jacks at 6 a.m. every morning in the name of public health, you know, because there's these massive redistributions in costs. And one of the final things that Ohio judges are moving towards that should be of great concern to you is the notion that our rights come not from the Almighty, but from the legislature. And again, the preamble says, we the people of the state of Ohio are grateful to Almighty God for our freedom. In 2000, in the year 2000, a case called State v. Williams, Justice Moyer wrote the majority opinion for a unanimous Ohio Supreme Court. Justice Moyer, if you go into the Ohio Supreme Court, was the Chief Justice for many years. He was deceased several years ago now. And there's a giant portrait of him there. It's the very first thing that you see. He's highly respected by the judiciary throughout the state. But Justice Moyer was very much what you would call a moderate, or somebody who believed in these notions of judicial restraint, that I would actually call judicial activism, because he's not forcing the state constitution. And so here we have this notion that our rights come from our Creator, and we have this notion of natural rights. Remember Article 1, Section 1, the very first section of Ohio's Constitution. And yet we have Justice Moyer saying in 2000, a unanimous opinion, that our rights come from the legislature. It is the legislature who defines the rights of man in Ohio. And that Article 1, Section 1 has never been used to protect individuals' rights and can't be used in the future. And of course, that's fundamentally wrong. We, at 1851, have pinpointed 3, 5, 7 Ohio Supreme Court cases relying solely upon Article 1, Section 1 to protect the rights of individuals in our history. Most prominently, the right to self-defense. So that's where it comes in. These are called unenumerated rights. So nowhere does the Ohio Constitution say you've got a right to self-defense per se, but courts would always say, no, it's this natural right to self-defense. There are certain things that are endemic in being a human being. One is to defend your own life, to defend your property, and that comes from Article 1, Section 1. Well, the courts are quickly writing that out of the Constitution, and that's something that has to be stopped. So, I've talked a great deal about what's in the Constitution and what the problems I see are. Now, what are the solutions to this judicial application of the Ohio Constitution? Well, one is you can simply pay more attention to who's running for office and be cognizant that the general election doesn't really matter that much. Oftentimes, judges run unopposed. You maybe noticed that they don't have a party affiliation. Many of you have shown up to vote the day of, and you've seen a name for judge, and you have no idea who this person is. Some of you even voted for people not knowing who they are, right? You say, well, Thompson looks like a good last name. Vote for Thompson. He seems like he'd be a good judge. You know, he's got a solid name. So, I mean, this is how we elect our judges. Very few people pay attention. But what that means is there's tremendous opportunity there because very few people pay attention. I believe very heavily in the triage or comparative advantage approach to policy work. At 1891, we try to focus on areas that are underappreciated, undervalued, where not everybody focuses. Things like the Ohio Constitution. And I suggest to you that as well organized as your liberty groups are here in Southwest Ohio and throughout the state, there's a major opportunity to have an impact on these judicial races and to protect your constitutional rights. So to do the very thing that you care about the most with the branch of government that controls it the most. The very thing that we pay attention to the least. And it really involves getting involved probably in the primary process where most of these judges are vetted and chosen. And at 1851, we've got a judicial questionnaire that helps vet these judges. And if any of you find that you need that in order to make some decisions and decide who to support, we try to keep it under wraps, but we're happy to share it with you if you're actually going to use it. But, you know, we've got this mountain of difficult precedent. So maybe it's not just enough to pay attention to your judicial races, which are all, everybody's elected in Ohio, of course. Municipal court, trial court, common pleas, appellate court, and Supreme Court. It may be that something more radical is appropriate and deserves consideration. And that really brings us to the Constitutional Convention.